The continuation of the impeachment trial of the Honorable Chief Justice Renato C. Corona of the Supreme Court is hereby called to order, which shall be led in prayer by Senator William Defensor Santiago.
Technically, this is not a prayer, but a passage from one of the greatest Christian mystical writers who wrote under the name of Julian of Norwich. She's explaining the problem of evil in God's created world. On one occasion, the good Lord said, "Everything is going to be all right." On another, "You will see for yourself that every sort of thing will be all right." In these two sayings, the soul discerns various meanings. One is that he wants us to know that not only does he care for great and noble things, but equally for little and small, lowly and simple things as well. This is his meaning. Everything will be all right. We are to know that the least thing will not be forgotten. Another is this. We see deeds done that are so evil and injuries inflicted that are so great that it seems to be quite impossible that any good can come of them. As we consider these sorrowfully and mournfully, we cannot relax in the blessed contemplation of God as we ought. This is caused by the fact that our reason is now so blind, base, and ignorant that we are unable to know the supreme and marvelous wisdom, might, and goodness that belong to the Blessed Trinity. This is the meaning of the words, "You will see for yourself that every sort of thing will be all right." It is as if God were saying, be careful now to believe and trust, and in the end you will see it all in its fullness and joy. Amen.
Amen. The Secretary will now call the roll of senators.
The Honorable Senator Judges Angara, Arroyo, Cayetano Alan Peter Compañero, Cayetano Pia, Defensor Santiago, Drilon, Ejercito Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Legarda, Marcos, Osmeña, Pangilinan, Pimentel, Rector, Revilla, Soto, Trillanes, Villar, the Senate President.
With 19 senator judges present, the presiding officer declares the presence of a quorum. Majority Floor Leader.
Mr. President, may I ask the Sergeant-at-Arms to make the proclamation?
The Sergeant-at-Arms is directed to make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the February 29, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the February 29, 2012 Journal of the Senate sitting as an impeachment court is hereby approved.
Appearances, Mr. President.
The Secretary may now call the case.
Case number 002-2011 in the matter of impeachment trial of Honorable Chief Justice Renato C. Corona.
Appearances, Majority Floor Leader.
Good afternoon, Your Honors. Good afternoon, Your Honors. The prosecution is ready. Same appearance, Your Honor. We're ready till 7 o'clock, as agreed, Your Honor. Thank you.
As noted.
For the defense, Mr. President.
For the defense, Your Honor, the same appearance. We are ready, Your Honor.
Noted. Majority Floor Leader.
Mr. President, counsel for Chief Justice Corona filed a motion to suppress illegally obtained evidence seeking to expunge from the record all evidence offered Mr. President.
The motion to suppress illegally obtained evidence dated February 22nd, 2012 is hereby denied for lack of merit. The clerk of court is directed to include the entire resolution in the record of the impeachment court.
Thank you, Mr. President. Just for the record, as requested by Senator Pimentel, this motion was voted on unanimously by the members of the court.
Majority Floor Leader.
Mr. President, also as directed by the court, the House panel of prosecutors filed on March 2, 2012, their formal offer of documentary evidence, while the counsels for respondent Chief Justice Corona, also as directed by the court, submitted their comments, objections thereto on March 7, 2012. The impeachment court has ruled and made this representation read the dispositive portion of the ruling of the court.
Proceed. Please read the dispositive portion of the ruling of the court.
In view of all the foregoing, acting on the formal offer of documentary evidence of the prosecution and the comment objections of the defense thereto, the court resolves to admit Exhibits A to 7Os and Exhibits 7Qs to 10Ns of the prosecution, subject to the appreciation of the individual senator judges as to their weight and sufficiency for the purposes for which they have been offered. Further, the foregoing documentary exhibits are admitted as part of the testimonies of the witnesses who testified thereon. The tender of excluded evidence consisting of Exhibits 7Ps to 7Ps-7 is hereby disallowed for being improper, as these documents have already been excluded by the court because they tend to prove bribery, a crime not alleged in Article 3 of the Articles of Impeachment. The tender of excluded evidence serves no purpose because there is no appeal from the decision of this court. The prosecution is deemed to have rested its case, subject to its reservation on the presentation of evidence on the dollar account of Chief Justice Renato Corona, should the Supreme Court rule that the presentation of evidence of such bank accounts before this court will not violate the provisions of Republic Act 6426. The initial reception of evidence for the defense is set on March 12, 2012 at 2 o'clock in the afternoon. So ordered, March 12, 2012, Pasay Chief.
Your Honor.
Majority Floor Leader.
Your Honor, please. Your Honor, please.
Mr. President, the prosecution wishes to be recognized.
Your Honor, please, may we just reiterate, Your Honor, that with the admission of our documentary exhibits, as well as the testimonial evidence of our witnesses, Your Honor, the prosecution is resting its case, subject to the reservation we have earlier made pertaining to the dollar account of the Chief Justice's court.
Well,
Thank you.
just wait for the written resolution of this particular matter by the court, and you may make a comment or assert your reservation after you have read it.
Thank you, Your Honor.
Okay. Majority Floor Leader.
Yes, Mr. President, in compliance with the directive given by the presiding officer, the prosecution filed a notice manifestation confirming their oral manifestation that they have terminated the presentation of evidence on Articles 2, 3, and 7 of the Articles of Impeachment, and that they will no longer present evidence on Articles 1, 4, 5, 6, and 7. the prosecution submits that the impeachment court need not vote upon the charges in the above-mentioned articles. On March 8, counsel for Chief Justice Corona filed a motion to dismiss, seeking to dismiss the charges against the Chief Justice under the same articles with prejudice in view of the prosecution's failure to prosecute and present evidence in relation thereto. I move that the presiding officer rule on the motion.
Thank you. Regarding the motion of the defense to formally dismiss Articles 1, 4, 5, 6,
And 8.
and 8
Yes.
of the Articles of Impeachment, the impeachment court in a caucus decided not to act and not to entertain and act on the motion to dismiss. With the clear understanding, however, that no evidence from both prosecution and defense panels will be received by the impeachment court on Articles 1, 4, 5, 6, and 8, and furthermore, that the members of the impeachment court will not render any vote on Article 1, 4, 5, 6, and 8, and that no verdict of the impeachment court will be rendered on Articles 1, 4, 5, 6, and 8. So ordered. Majority Floor Leader.
Mr. President, the prosecution also confirmed their oral manifestation that they are reserving and not waiving their right to present evidence pertaining to dollar accounts of the respondent in connection with Article 2. On March 7, counsel for Chief Justice Corona filed its opposition thereto, praying that the impeachment court deny the reservation to present additional evidence on alleged dollar accounts. I move that the presiding officer rule on the motion, Mr. President.
This matter has already been ruled upon previously by this court when we ruled on the suppression of the evidence involved. But nonetheless, I would like that the both panels will read the ruling of the court with respect to the admission of the offered evidence by the prosecution, as well as its ruling on the objections or comments filed by the defense on that offer of evidence. So ordered. President Leader.
Yes, we are in receipt of a request for issuance subpoena ad testificandum et duces tecum to the Secretary General of the House of Representatives, several representatives, and the executive producer program manager of the news program Head Start of ABS-CBN News, or the official custodian of its news videos, to appear for examination before the impeachment court so as to their knowledge or personal knowledge regarding the verification of the verified impeachment complaint. I move that the presiding officer rule on the motion.
This is in connection with the ABS-CBN.
And also the subpoena for the House of Representatives and other representatives on the verification of the verified impeachment complaint, Mr. President.
Since the purpose of the subpoena is to present evidence on the circumstances of the verification of the articles of impeachment, which has been previously ruled upon by this court when it considered the motion for preliminary hearing filed by the defense, the request is hereby denied. Now, with respect to what else has been? Yeah. Majority Floor Leader.
Yes, well, all of the requests are denied, Mr. President, for the record, including the request for the ABS-CBN custodian. So, finally, Mr. President, on March 9, the prosecution filed its motion requesting that the defense panel be directed to manifest the order of its presentation of evidence in order to afford the prosecutors the opportunity to prepare for the reception of evidence of the defense. I move that, well, Mr. President, I move to submit the motion for consideration by the presiding officer.
Well, to be fair, in order to have an orderly proceeding, the defense is hereby ordered to comply. Majority Floor Leader.
Mr. President, we are now ready for the presentation of evidence by the defense.
The defense may now take the, may now start presenting their evidence.
Your Honor, please, may we be allowed to be heard in connection with the rulings made by the Honorable Impeachment Court on our motion for the hearing on our affirmative defenses, Your Honor. We were made to understand, Your Honor, that the same is hereby denied, Your Honor.
Yeah.
We understood in the previous ruling of this Honorable Court earlier made, Your Honor, or promulgated, that what was denied is a preliminary hearing. And this is in conjunction with expediting proceedings, Your Honor. We were then satisfied that the introduction of our evidence, Your Honor, in connection with the affirmative defense shall be made in the trial on the merits of this case, Your Honor. And that we are prepared to do, Your Honor. We have subpoenaed, we have requested the appearance of our witnesses and also requested for the subpoena of our other witnesses, Your Honor. We have not received any final adjudication on the validity and or plausibility of the affirmative defenses we have set up in our answer, Your Honor. And this more particularly involved the existence, Your Honor, of probable cause and other matters in relation thereto, which nullifies the entirety of the proceedings being held by this court. We are charged with notice, Your Honor, that there may be some objection to this, because allegedly we have gone this far, but we are entirely hopeless, Your Honor. We have filed a motion for preliminary hearing that was denied, Your Honor. And our understanding of that denial is we are precluded from presenting evidence on the affirmative defenses at that time, Your Honor, but never at any instance before the case submitted for decision. Hence, we proceeded in participating with the trial on the merits, Your Honor. And there are so many instances, Your Honor, even in the ordinary court of justice, Your Honor, where a preliminary hearing on the affirmative defenses or a motion to dismiss or a demurrer to the evidence had been held in abeyance only to be resolved at the time or after the parties had been heard in a trial on the merits. That was our assumption, Your Honor. We have no reason to entertain the belief, Your Honor, much less concur with the present developments that our affirmative defenses have been totally denied, Your Honor.
Your Honor, I hope you understand our position. The rules governing preparation of the complaint of on impeachment or resolution on impeachment is a function of the House, and that the function of trying and deciding the case is lodged in this court. Now, this particular impeachment case was filed under paragraph 4 of section 3 of Article 11, and I would like to read to the public and to this court the provision of paragraph 4. In case the verified complaint or resolution of impeachment is filed by at least one-third of all the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith begin. As far as this court understands this provision, there are two parts: that the complaint must be verified and that it must be filed by at least one-third of the House. If I remember correctly, and I have here, may I have the articles of impeachment?
Yung ruling na pinuha natin.
Is this the articles of impeachment? I have here the articles of impeachment. Republic of the Philippines, House of Representatives, House of Representatives Complex, Constitution Hill, Quezon City, in the matter of the impeachment of Renato C. Corona as Chief Justice of the Supreme Court. Representatives Neil C. Tupas, Jr., Joseph Emilio A. Abaya, Lorenzo R. Tanyada III, Reynaldo V. Umali, Arlene J. Bagao, and other complainants comprising at least one-third of the total members of the House of Representatives are indicated below. So there are 5 named congressmen. And as far as we can see, the articles of impeachment filed in this court has been verified. Now, we have to ask all the members of that court, that prosecuting body, whether they read these impeachment articles of impeachment or not. That would be tedious, and I think that what was contemplated, as far as the understanding of this court, what was contemplated, that as long as 1, 2, 3, 4, 5, or 100 of those who filed this case verified this complaint, that is the verified complaint spoken of in paragraph 4 of section 3 of article 11. And so therefore, when it reached this court assumed jurisdiction, and in fact we have gone through trial already. The answers and reply to the answers have been filed, and we proceeded to trial. The prosecution closed its presentation of evidence. It's now the turn of the defense to present its evidence, and I think it is the opinion of this court that it's too late to raise the question of verification at this point.
If Your Honor, please, may we be allowed to say something on this particular issue, Your Honor?
Yeah, proceed.
The record should show, Your Honor, that right after we have filed our answer to the impeachment complaint, Your Honor, we have also availed of the remedy of filing a motion for a preliminary hearing on our affirmative defenses. We were then abiding by the jurisprudence on the point laid down in the case of Francisco et al. Versus House of Representatives, where it is stated that if there is a defect casting doubt or legality or violative of the Constitution on the part of the impeachment complaint, the same may be raised in the House of Representatives and also in the Senate prior or during the trial of the case. And if the Senate rules either way, then the remedy is with the Supreme Court. That was a dictum laid down in that case, Your Honor. Now, we were also guided by the fact, Your Honor, that in the same case, there was an adjudication to the effect that raising the issue of non-existence of probable cause goes into the very merits of the case, Your Honor. And as held by the Supreme Court in that case, Justice Panganiban speaking for the court, it stated that during the oral argument, May I be allowed to read for the record, Your Honor?
Yes.
Yeah, right. Senator Salonga and Petitioner Francisco Chavez denounced the second impeachment complaint as violative of due process. They argued that by virtue merely of endorsement of more than one-third of the members of the House of Representatives, the Chief Justice was immediately impeached without being afforded the twin requirements of notice and hearing. In here, Your Honor, the complaint was filed by more than one-third, Your Honor. The proceedings were therefore null and void ab initio. And Justice Panganiban, who was then the Chief Justice, I must agree. The due process clause enshrined in our fundamental law is a condition sine qua non that cannot be ignored in any proceeding.
Just a minute. The proceedings of which body, the House or this court, is going to be
This court
is supposed to be null and void?
Yes, Your Honor, including the proceedings before this court, because there is not the impeached public official is not precluded from raising the same issue before this honorable impeachment court, Your Honor.
Well, this is a variant of opinion between the defense counsel and this court, because then if you insist that we will make a finding of probable cause as a consequence of determining whether there has been a probable cause in the articles of impeachment submitted to this court, then we will make a ruling to that effect.
It's not that a ruling, Your Honor, on the existence or non-existence of probable cause is being asked by this representation, Your Honor, but it is a matter of fact that there was no determination of probable cause. In other words, there were no evidences, there were no allegations that will prove the existence of probable cause. And yet, the public officer involved was immediately impeached. Supreme Court said that is violative of the right against due process because due process requires notice and hearing. And it applies in all cases, notwithstanding the fact that this is a proceeding which is sui generis, Your Honor. And the Supreme Court went further, Your Honor. Due process clause enshrined in our fundamental law is a condition sine qua non that cannot be ignored in any proceeding, administrative, judicial, or otherwise. It is deemed written into every law, rule, or contract, even though not expressly stated therein. Hence, the House rules on impeachment, insofar as they do not provide the charged official with notice and opportunity to be heard prior to being impeached, are also unconstitutional. We are predicating our action on this particular provision, particular statement of the Supreme Court, Your Honor. In addition thereto, likewise, the Honorable Justice Santiago, in a concurring opinion, likewise stated, and may we be permitted to place it on record, Your Honor?
Yes.
The impeachment complaint suffers from yet another serious flaw. As one of the amicus curiae, former Senate President Tobito Salonga pointed out, the signing of the impeachment complaint by the purported one-third of the congressman was done without due process. The Chief Justice, against whom the complaint was brought, was not served notice of the proceedings against him. In here, likewise, what is referred to is an impeachment complaint filed by at least one-third of the members of the House of Representatives. And the Supreme Court, going further, stated, no rule is better established that under due process clause of the Constitution than that which requires notice and opportunity to be heard before any person can be lawfully deprived of his right to be heard, before any person can be lawfully deprived of his rights. Indeed, when the Constitution says that no person shall be deprived of life, liberty, or property without due process of law, it means that every person shall be afforded the essential element of notice of any proceedings. Any act committed in violation of due process may be declared null and void, Your Honor.
Is it the position of the defense counsel that indeed there is no probable cause in this case?
That is our position, Your Honor. And if we were allowed during the early days before the evidence of the reception in chief, Your Honor, we would have done so right at that moment. We seem to be
But to say under our rules of impeachment in this Senate, we do not have a provision governing preliminary hearing on defenses in impeachment cases.
Yeah, but that was...
And we are authorized by the Constitution to devise our own rules of impeachment. This is not rules that the Supreme Court can formulate for this House. It is the formulation of this House itself.
We are in total conformity with that, Your Honor. We are likewise in full accord with the said pronouncement of the Honorable Presiding Justice. But what we are invoking is the right of the impeached public official, in this particular instance, the Honorable Chief Justice Corona, to his right to due process. And the right to due process recognizes that it is available in all kinds of proceedings, including impeachment proceedings, Your Honor. It does not exempt impeachment.
Must the determination of probable cause be done by the House of Representatives, or could it be done by this court?
It may be done, Your Honor, by the House of Representatives, and any ruling by the House of Representatives may be brought before the Senate Impeachment Court if the opportunity so arises. And a ruling thereon may be made, either a denial or a grant, Your Honor, in which case judicial remedies are afforded in favor of the aggrieved party if there is an abuse of discretion that brings about the power of judicial review on the part of the Honorable Supreme Court, Your Honor.
The Majority Floor Leader.
Yes, may we recognize Senator Miriam Defensor Santiago, Mr. President.
The gentle lady from Iloilo.
Mr. President, may I offer the humble submission that in my view there is no constitutional issue involved. There is no constitutional issue of due process or equal protection. Instead, there is a specific rule in our rules of court, Rule 16, Section 6, which is entitled Pleading Grounds as Affirmative Defenses, and it quotes in part, if no motion to dismiss has been filed, any of the grounds for dismissal provided for in this rule may be pleaded as an affirmative defense in the answer, and in the discretion of the court. I would like to emphasize this phrase. In the discretion of the court, a preliminary hearing may be had thereon as if a motion to dismiss has been filed. The annotations based on jurisprudence indicate that unlike a motion to dismiss based on the failure of the complaint to state a cause of action, which may be resolved solely on the basis of the allegations of the complaint, a motion to dismiss raising an affirmative defense that there is no cause of action as against the defendants poses a question of fact that should be resolved after due hearing. Therefore, the issue is really whether the defense is there is no cause of action as against the defendants, and the question is a question of fact. Then, in that case, a hearing in the proper discretion of the court might be ordered, but otherwise, it is completely discretionary with the court. A party effectively submits to trial court's jurisdiction by praying for the dismissal of the complaint on grounds other than lack of jurisdiction. So, just to repeat for summary, to summarize, granting a hearing on a ground alleged as an affirmative defense is, as the rules say, in the discretion of the court. That is my comment.
Counsel, you are not questioning the jurisdiction of this court.
If there is really no probable cause, Your Honor, and therefore the impeachment complaint is a total nullity, then there could be no jurisdiction that the Senate Impeachment Committee can acquire, Your Honor.
If the issue of probable cause could be decided on the prosecution side as well as in the court itself, this is my understanding of the rule in the ordinary courts, criminal cases.
We appear to be quite insistent on this particular matter, Your Honor, because we have sought guidance from the jurisprudence of the Honorable Supreme Court in connection with this matter. More particularly, the point that whether probable cause could be raised even after the remand of the impeachment case to this Honorable Supreme
But
Court.
in the case of Francisco, the articles of impeachment has not reached this court. The case arose out of the proceedings in the House of Representatives. And so therefore, the Francisco case is not on all fours with respect to the factual situation in this particular impeachment.
That's correct,
proceeding.
Your Honor. But it is a guidance, since there is no categorical provision under the rules of impeachment of the Senate Impeachment Committee. Many times we are at a loss, Your Honor. Here is a problem. We wanted to argue either against or for, but there is no definite provision under the rules of the Senate, Your Honor. So where do we go?
Do you know why it is like that, Your Honor? Because there is no appeal in the decision of this court.
Yes, Your
There
Honor.
are no reversible errors. There are no assignment of errors. Once a verdict is pronounced of acquittal or conviction, if it's acquittal, the government cannot appeal. If it is conviction, the respondent cannot appeal. There are no assignment of errors. There are no reversible errors. So that is the reason why in an impeachment trial, as far as I know, there is no motion to dismiss. There are no motions for preliminary hearings. That's why the Constitution says trial shall forthwith proceed. It did not say begin, proceed. Go ahead and try it and all the way to judgment. Except that you have to respect the rights of private parties that may be involved.
We were this insistent, Your Honor, because we are worried about the resulting consequences of the aforesaid pronouncement, Your Honor, with due respect to the Honorable Court, on the impeached public official, Your Honor. We have here a portion, Your Honor, and before we are considered terminated in our argument, Your Honor, may we read it for the record, Your Honor.
We will understand your position. If you want to read your argument, go ahead.
The question on the sufficiency of the complaint in form may again be brought to the Senate by way of proper motion, and the Senate may deny the motion to dismiss the complaint depending on the merits of the ground raised. After the Senate shall have acted in due course, its disposition of the case may be elevated to this court pursuant to its judicial power of review. So we are referring to a situation where an apparent grave abuse of discretion existed on the part of the impeachment court.
What this court wishes to avoid is a clash between the Supreme Court and this court. Because, frankly, I must say that this court is not willing to surrender its power to make a judgment in impeachment cases. And so, if the decision of this court with respect to the existence of probable cause is reviewable by the Supreme Court, then, in the opinion of this presiding officer, and I think as well as of this court, that will mean that the Supreme Court will override the judgment of this impeachment court. And so therefore, with most regret and with due respect to the Supreme Court, we will deny any interference in the judgment of this impeachment court.
Mr. President.
Well,
trial suspended. I will consult the members of the court.
thank you, Your Honor. Thank you, Your Honor.
Mr. President.
As expected, Corona's counsels addressed what they believe is the crux of the problem on day 27 of the impeachment trial of Chief Justice Renato Corona. They continued to argue that the verified complaint is null and void since the complaint was railroaded by lawmakers who signed the complaint without having time to read its contents. They said the complaint has no probable cause and thus the impeachment court has no jurisdiction over the case. However, the Senate impeachment court denied the defense motion for verification of the impeachment complaint and emphasized that the impeachment court has sole jurisdiction to decide the case. There is a current suspension of the trial right now as the presiding officer, Juan Ponce Enrile, is discussing the issue with other senator judges. Now, also earlier this morning, senator judges held a caucus to decide on important and significant issues pending in the court. Senator judges decided to admit most evidence of the prosecution, including both foreign and peso bank accounts that were presented to the court that were owned by the Chief Justice. The only evidence that was denied by the Senate impeachment court were the records relating to the Philippine Airlines case that alleged bribery because they said this was not written in the impeachment complaint against Corona. The Senate also denied the defense's request for subpoenas of two other congressmen who did not sign the complaint to testify at the impeachment court. They cited parliamentary privilege for denying the motion. The Senate impeachment court also decided not to act on the defense's motion to dismiss the 5 other articles dropped by the prosecution. Stay tuned with us as we wait for the resumption of the Corona trial.
Trial resumed. Majority Floor Leader.
Mr. President, may we recognize Miriam Defensor Santiago?
The lady senator from Iloilo is recognized.
Try and very humbly explain. Hello? For the second time, I would like to try and very humbly explain why the ruling of the court, as articulated by our presiding officer, is on all fours with our rules of court. Rule 16 governs motion to dismiss and deals with the separate grounds for filing a motion to dismiss. Here, the pertinent grounds are related to each other. You could file a motion to dismiss on the ground that the court has no jurisdiction over the person of the defending party, or that the court has no jurisdiction over the subject matter of the claim. With respect to jurisdiction over the person of the defending party, the Supreme Court has taught us it is a settled rule that the party cannot invoke the jurisdiction of a court to secure affirmative relief against his opponent, and after failing to obtain such relief, repudiate or question that same jurisdiction. So what we are being taught is that if you've already accepted jurisdiction of the court and you've even filed affirmative defenses for the consideration of that court, but your affirmative defense is denied, after doing that, you cannot turn around and then repudiate the same question of jurisdiction. Your hands are already tied. And then the other ground is that the court has no jurisdiction over the subject matter of the claim. Once more, to jurisprudence, we can turn and find the following lesson. While jurisdiction may be assailed at any stage, a party's active participation in the proceedings before a court without jurisdiction will stop will stop such party from assailing such lack of it. Again, the point is the same. You've already accepted jurisdiction, you've tried to obtain relief, and if you don't obtain it, you cannot now turn around and say, but after all, you have no jurisdiction over me. So I'm afraid that the ruling of the impeachment court that no preliminary hearing will be conducted on a special affirmative defense is on all fours with the rulings of our Supreme Court and the rulings as articulated by our President, our presiding officer, have always been totally congruent with the rulings of the Supreme Court.
Thank
Mr.
you.
President, Senator, may we recognize Senator Escudero, Mr. President, before you.
The gentleman from Sorsogon.
Thank you, Mr. President. With the permission of the presiding officer, may I address some questions to the lead defense counsel, Attorney Cuevas? Sir, if I may ask, it is clear that the impeachment court already made a ruling with respect to the motion for preliminary hearing and even on the affirmative defenses itself with respect to the jurisdiction of the Senate and the procedure adopted by the House. The basic concern, Attorney Cuevas, is you might call all 188 signatories, and you might end up, being bogged down on this issue that has already been decided upon and ruled by the Senate. That's a basic and valid concern by the impeachment court, sir. And secondly, if it was for the purpose of establishing the absence or presence of probable cause, as mentioned by Senator Santiago and ruled by the court in its written ruling, that has already been disposed of by the impeachment court. However, if the purpose is perhaps to set the tone or to, by way of preliminary, to lay the predicate for your general theory of the case, and you will not present 188, and perhaps one or two witnesses on this matter, perhaps some understanding or bending over backwards may be given. But the concern, again, Attorney Cuevas, is baka yung buong 188 ho, patawag ho ninyo. Ano ho ang balak ninyo?
That is far from my mind, Your Honor, because our attack is not on the number first. Now, secondly, I hope you pardon me for disagreeing with your dissertation that there was already a ruling on this particular case. May I cite the January 12, 2012 dispositive portion? In view of all the foregoing, the motion for preliminary hearing filed by Chief Justice Renato Corona is denied for want of merit. So what was denied in our understanding, and it is clear to us, is only the right to a preliminary hearing. not the affirmative defenses, if Your Honor, please.
The court will decide on that, Attorney Cuevas. But may I get?
No, I'm just saying we have every reason to rely on this. If there was a categorical pronouncement, then probably we could have taken other remedies, if Your Honor, please.
But may we know, Attorney Cuevas, on this issue and on this matter, in the absence of a pre-trial wherein we would have obtained the list of witnesses, insofar as this issue is concerned, who and how many witnesses do you intend to present, if you may know?
Well, we have stated earlier that we are presenting about 20 witnesses, Your Honor, all the entire impeachment proceedings.
On this topic, sir, Your Honor.
Now, on this topic, probably 3 up to 5. Because, for instance, in 3/4, 2/3, let's say there are this number, and 2 or 3 of them were intimidated or coerced to sign one way or the other. So the number representing at least 1/3 is already obliterated. So to us, that will be a facade of false information.
Mr. President,
Because you
Your
have
Honor.
a definite number in order to determine what is 1/3. Now, supposing of that 1/3, 1 or 2 were merely coerced, they were compelled to affix their signature without being voluntary on their part. Will that not at least change the color of their signature attached to the affixed to the complaint? That is because we have every reason to rely on the jurisprudence on the point. Since there is no definite article, much less any section of the impeachment rules by this honorable court, then we have to resort, or we have to go to other sources, Your Honor. And we are not totally left without any support whatsoever. What we read into the records are questions where the impeachment complaint was filed by at least 1/3. And to us, it is clear that the mere fact that the complaint is verified complaint was filed by at least 1/3 does not exempt the petitioner or the complainant from observing the requirements prescribed by law in order to comply with the requirements of due process. That is our point. Because left with no alternative, where do we go? There is no appeal, but there is a violation of the constitutional right of the accused. That is therefore a ground for the Supreme Court to take cognizance of the case. If that is a ground, then how else could we assert it? Except by pleadings, and if we do not agree with the decision of the, sorry to say, we do not agree with the decision of the Honorable Impeachment Court, then maybe other remedies are available to us.
Mr. President, for the record, I agree with the impeachment court with respect to the non-issuance of subpoena to members of the House. However, nothing bars a member of the House from testifying voluntarily if they are called by the defense as their witness.
No.
And insofar as allowing the defense to present evidence on this matter, for as long as it is on a short leash and will not entail the calling of all 188 of them, which would be unreasonable to say the least, and I think Council will agree with me.
Yeah, we have already. I'm sorry.
For the record, Mr. President, Your Honor, that is the position of this representation. So the defense can be given some leeway with respect to developing their case.
I'm not yet crying for liberality in favor of the impeached public official. Many a times, the prosecution had been crying for the extension of liberality on their part. If there is anybody who should cry or call for liberality, it should be the impeached public official, being the accused in a criminal case. Never is there a time where the prosecution asked for liberality. I was a fiscal for more than 20 years. I never asked for any liberality.
We submit and we thank the distinguished counsel for the defense for his
Thank you. Now,
patience,
may
Mr.
we
President,
pose a
Your Honor.
question, if Your Honor, please. We have 3 members of the House of Representatives whom we intend to utilize as adverse witnesses, Your Honor. If we call for a subpoena, if we ask for a subpoena to compel their appearance, Your Honor, it may again fall under the previous ruling of this Honorable Court. But this time, we are not calling them as ordinary witnesses, Your Honor. They are calling them as adverse party, and the law allows us under the rules of court, Your Honor.
Who are the adverse party that you want to...
For instance, Congressman Abaya, Your Honor, Congressman Kimpo, and Congressman Tanyada, Your Honor. then we will dispense with
Mr. President, may we
Congressman
recognize,
Gonzales. We are calling them not in their capacity as congressman, Your Honor, but in their capacity as complainants, Your Honor. So they are adverse party, Your Honor. If the court will not lend its assistance to us, we'll have no alternative. We cannot compel them to come here.
All right.
Mr. President, may we recognize the minority leader, Senator Cayetano, and then Senator Drilon.
The minority floor leader.
Magandang hapon, Mr. President. Justice Cuevas, magandang hapon po.
Magandang hapon din po.
Gusto ko lang po maintindihan ng mabuti yung posisyon niyo at yung pinag-uusapan natin. Narinig ko po yung terms na due process and in very layman's term, yung makinig muna bago humusga. Hindi po ba? Tapos yung probable cause, no? Determination of probable cause. Basically, tama ho ba, ang hinihingi nyo sa amin, magkaroon ng preliminary hearing para i-determine precisely kung nagkaroon ng ang House ng determination ng probable cause o hindi.
Wala na po, because that was denied already.
Okay.
So when we requested for, when we moved or requested for a preliminary hearing, there was already this resolution of January 18.
Sige po. So now you're asking us
to allow, I'm sorry.
Go ahead, sir. Doon naman papunta yung question, please.
We were praying for the liberality of this court and its magnanimity to allow us to present evidence, even on a trial on the merits, to prove our point, Your Honor, which we were not able to do because our motion for a preliminary hearing was denied, Your Honor.
And sir, what you want to prove is that walang determination ang House ng probable cause, ergo, it's a violation of the due process of your client, the impeached official, the Honorable Chief Justice of the Supreme Court. In a nutshell, ho. Go ahead po.
Not only that it is a violation of the due process right of the accused, Your Honor, but it is a constitutional mandate on the part of our judicial department that the accused should be entitled to due process. Notify him, allow him to be heard, and then decide the case.
Okay. Sir, the reason I ask this question is because I am sympathetic in general.
Thank you.
And I always use the example that we use in law school na ang Diyos nga mismo nakita niya na kinain ni Eva at Adan yung mansanas pero hindi niya kagad hinusgahan, tinanong niya, di ba, ba't kayo nagtatago, anong ginawa niyo? So before he condemned, he asked them a question. Having said that, Your Honor, if we look at Article 11, Accountability of Public Officials, Section 3, Paragraph 4, no? In the case of verified complaint or resolution of impeachment is filed by at least 1/3 of all of the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. So my problem, Your Honor, in being sympathetic with your plight is this. If we granted you a preliminary hearing, or if we allow you to present evidence now, saan to pupunta? Pag nagruling po kami na walang probable cause or walang determination of probable cause or hindi kayo dininig ng lower house or ng House of Representatives, sorry to use lower house, the House of Representatives, we will be in effect amending the Constitution. We will be now saying that mali ang paragraph 4 ng Section 3 ng Article 11 because we will be basically telling the House kailangan nyo mag-hearing muna. May I finish, Your Honor?
Go ahead, I'm sorry.
But it is very clear here that when you have 1/3 of all members signing the verified complaint or resolution, it shall automatically constitute an article of impeachment. So unlike a case in the fiscal's office, na kailangan ng piskalya i-inform pareho, makinig sa parehong side, and then determine whether or not meron probable cause. In the case of paragraph 4, pag binasa ng congressman at pinirmahan at umabot sila ng 1/3, yun na po ang determination ng probable cause. The Constitution itself does not call for, I'll let you give your side, Your Honor, after this, but just to elaborate and please tell me if mali ang pagkaintindi ko or kung you have a different theory about, specifically I'm talking about section, paragraph 4, no? Dahil ako'y naniniwala this is the mode na inakyat sa atin ng impeachment, no? So Your Honor, pag binasa ng congressman to, pag umabot ng 1/3, diretso na to sa Senado. Pag hindi to umabot ng 1/3, nagkakaroon ng proseso sa lower house under paragraphs 1, 2, and 3. During the impeachment of President Gloria Macapagal Arroyo, Congressman T.G. Ginggona here, myself, Congressman Joel Villanueva, then Congressman now Senator Chis Escudero. Ito po tanong namin kay sa mga kadibate namin on the opposite side. Sabi namin sa kanila, do you mean kahit na napakalakas ng final namin resolution, kahit klarong-klarong may probable cause, pagka hindi kami naka one-third, ibig sabihin, ang finding nyo walang probable cause. On the other hand, even if it's a scrap, it's a piece of paper na walang laman. If one-third signs, it will go to the Senate at meron ng probable cause yun. And there was always unanimity there. Na pagka yung one-third nakapirma, pumunta na sa amin yon, ang trabaho namin, hindi i-determine yung probable cause. Ang i-determine namin, number one, meron bang impeachable ground? May ground ba for impeachment under the Constitution? Then number two, proceed with trial, whether or not nga guilty yung tao. So, yun po ang problema ko. Assuming I say, I asked for a reconsideration because I voted with the majority, and I think the ruling of the presiding officer and of the impeachment court is correct. But assuming for the sake of argument, sabihin natin dapat bigyan ng hearing, dapat payagan ang defense na magpakita ng ebidensya na hindi nagkaroon ng due process or ng probable cause, no? Pero ang Constitution na po nagsabi na kapag kayong one-third may nakapirma, due process na yon. Dito na siya magpaliwanag. Ika nga ng mga polis, boss, sa presinto ka na magpaliwanag. Dito po ang sinabi, boss, sa impeachment trial ka na magpaliwanag, wag na sa Committee on Justice. So, Your Honor, my question is, and answer the way you would like to, sir, is, are you saying that unconstitutional ang paragraph 4 or this paragraph is in fact violative of other parts of the Constitution? Kasi if we return this to the lower house, yung effect po, we will nullifying this mode of elevating an impeachment case to the impeachment court.
No,
I'm through, Your
Pwede na
Honor.
ako.
Yes.
Thank you, Mr. Senator. It is not merely Justice Cuevas espousing that view. It is the Honorable Supreme Court already. In the two cases I have mentioned, the impeachment complaint was filed by at least one-third. And the Supreme Court said that is no exemption.
So
Your Honor, determination of
my
probable
question
cause.
is, can the Supreme Court amend the Constitution?
Well, it's not amending. That is the interpretation.
But how can you interpret it any other way? Ang nakalagay po dito, in case a verified complaint or resolution of impeachment is filed by at least one-third of all members, the same shall constitute the article of impeachment.
Correct.
Hindi po nakalagay dito, the House shall now have a hearing and determine
Wala rin
probable
naman nung
cause.
nakalagay dyan that there is no necessity of determining probable
Nakalagay
cause.
po, Your Honor, and trial by the Senate shall forthwith proceed.
Yes, but in this jurisprudence it is stated it can be asserted before the lower house.
Well,
Before the
go
house.
ahead, Your Honor.
If it is denied, then you can go to even if the impeachment case already filed. And if it's the impeachment court may act on it, either granting or denying. So it is a reconciliation.
Your Honor, I will not answer that statement about the Supreme Court because I think in our ruling we mentioned about the ruling of Chief Justice Davide in the Estrada trial. But I'll stop there. I thank you for answering those questions. But I just like to put that on record that I support the decision of the court. And I don't think there's any other logical interpretation of paragraph 4 which I read. No, I mean, if we're going to interpret it that would require the House to have a hearing, it will be the same as the other paragraphs, Your Honor. But anyway, I will let in this because of due process, and we hear both sides. We hear you're not arguing with me, I'm not arguing with you, but I just want to put that on record, Your Honor.
With due respect, Mr. Senator, if we follow that dictum, then there never can a time be when impeachable officers may be immune from impeachment proceedings filed by any disgruntled individual. Because all they have to do is gather at least one-third. And there is no more investigation. There is no more probable cause.
But, Your Honor,
it goes direct to the Senate.
That's precise.
If we follow that dictum, that will lead to disastrous consequences.
But, Your Honor, if you...
The security of tenure provision will definitely be laid to rest, and it may not be invoked by any impeachable
But
public.
just for the information of the court, Your Honor, that is precisely in the records of the debate of the Constitutional Commission. Yun po precisely ang debate nila. Na if you ask for a majority of Congress to impeach a public official, it will be very difficult to impeach a public official. Pag isa, 5, 10 naman, it will be very easy. So ano yung compromise? When 1/3 affix their signature in a verified complaint or resolution, automatic na, punta na po ito sa impeachment court. At tinanong nga doon, but will that be subject to abuse, etc.? Ang sabi nila, it's not that easy to get 1/3. And we cannot assume that the House of Representatives will not act in good faith. So, Your Honor, that's the balancing of accountability and transparency here. If you make it almost impossible, then you give the Supreme Court justices immunity. Ang presidente po, 6 na taon lang siyang immune sa suit. Ang Supreme Court justice, pag 55 years old ka na-appoint, ang sabi po nila sa mga Supreme Court cases, in fairness to them, not only now, matagal na itong mga kaso na to, hindi ka pwede mag-file ng disbarment, hindi ka pwede mag-file ng criminal case. Kailangan impeachment muna bago mo silang kasuhan. Dahil kung hindi, indirectly tinatanggal mo sila. So kung pahihirapan naman natin ng husto kung paano sila i-impeach, maghihintay tayo hanggang 70 years old na sila, hanggang mag-retire at dun mo lang pwedeng kasuhan, wala nang remedyo po ang taong bayan. Ang mamaya, wala nang pupuntahan.
Hindi po.
Your Honor, I was just responding to your thesis that it will be so easy. But I mean, I've been a congressman for 3 terms, and I've been monitoring Congress. I think ilan pa lang po ang na-impeach by this mode.
I think we have...
But thank you, Mr. President. Thank you for this time.
Mr. President, the Senator Drilon...
I think we have sufficiently argued this case. But anyway, the gentleman from Iloilo is recognized.
Mr. President, I'll be very brief. The defense here, Mr. President, is making a plea that they be allowed to present evidence on their affirmative defenses because allegedly the January 18, 2012 ruling did not rule upon the affirmative defenses but only the motion for a preliminary hearing. Mr. President, the grounds relied upon by the affirmative defenses is precisely the ground relied upon when the defense asked for a preliminary hearing. And in fact, on page 2 of the resolution of January 18, it says, the Chief Justice claims that since the verified complaint for impeachment lacks a proper verification, it should be treated as an unsigned pleading which produces no legal effect and should therefore be dismissed. The January 18, 2012 ruling of this court, Mr. Senate President, categorically validated the verification. It ruled, quote, it appearing that the filing of the verified impeachment complaint was made in accordance with paragraph 4, section 3, article 11 of the Constitution, there is no more need for a preliminary hearing to receive evidence on this matter, close quote. If there was no need to present evidence on the matter of the preliminary hearing, there is no need to present evidence on the affirmative defenses. So it is not true that it was only the motion for a preliminary hearing that was denied. It is the validity of the verification itself that was ruled upon. And the purpose, obviously, of a hearing on the affirmative defenses is to have the case dismissed because of lack of proper verification, which has already been ruled upon by this court on January 18, 2012. Thank you, Mr. President.
If that commentary, Your Honor, was made by the members of the prosecution arm, we would have no objection, Your Honor. We are worried, Your Honor, that this may be interpreted, Your Honor, as an argument by a prosecutor.
I take objection to the statement of the prosecution of the defense counsel, and that is totally improper. We are just reading. I am still speaking.
Go ahead.
Do not interrupt, because I was just explaining the ruling of the court.
May I request the majority floor leader to reread the ruling of this court on what date was it?
Resolution of January 18, 2012, Mr. President.
Yeah, read it.
The Chief Justice claims that since the verified complaint for impeachment lacks proper or a proper verification. It should be treated as an unsigned pleading which produces no legal effect and should therefore be dismissed. I will just read the pertinent portions. Mr. President, to continue in the resolution. During the impeachment proceedings of President Joseph Ejercito Estrada before the Senate, case number 001-2000, a motion to quash was filed by him, alleging, among others, that the verification in the impeachment contract was not the verification prescribed by the Constitution. The impeachment complaint, the contract was probably a typographical error. The impeachment court at that time found the verification to be sufficient and ruled that the perceived flaw in it was inconsequential and not fatal. Speaking through Chief Justice Hilario G. Davide Jr., who was the presiding officer of that time, the impeachment court stated in a resolution dated 29 November 2000 that verification, like in most cases, required by the rules of procedure, is a formal and not a jurisdictional requirement. It is mainly intended to secure an assurance that matters which are alleged are done in good faith or are true and correct and not of mere speculation. By Miriam Defensor Santiago. There appears to be no cogent reason to depart from this ruling. On its face, there appears to be no patent or obvious defect in the verification contained in the verified impeachment complaint. The wording or content of the same is substantially in compliance with the third paragraph of Section 13 of the Rules of Procedure in Impeachment Proceedings of the House of Representatives. It is not necessary for the verification to be couched in the language of the Rules of Court, inasmuch as this particularly wording is not strictly required by the Constitution. If this had been what was required, the Constitution would have specified the exact required wording of the verification. A verification is an oath or affirmation. Under the Constitution, there is only one instance wherein the exact form of an oath or affirmation is specified, and this is found in Section 5, Article 7, when the President, Vice President, or the acting President takes his oath or affirmation before entering on the execution of their office. Since there is no precise wording required for the verification of a complaint in case of impeachment under paragraph 4, Section 3, Article 11 of the Constitution, the actual verification in the complaint as per the rules of impeachment of the House of Representatives is sufficient and adequate for the purpose. In view of all the foregoing, the motion for preliminary hearing filed by Chief Justice Renato C. Corona is denied for want of merit. January 18, 2012, Mr. President.
All right. We have discussed this lengthily.
May we recognize Senator Arroyo, Mr. President, before
the gentleman from Makati and Bicol.
Thank you, Mr. President. May I ask the defense, just what is the objective of the defense in filing this motion? What is your goal? Because as I see it, supposing the Senate will grant your request, have a hearing, and then it turns out that your allegations about the defects, etc., are true, would you say that the Senate has to dismiss the complaint?
To us, it will appear...
Yes, I'm asking.
To us, Your Honor, it will appear that there is no valid complaint because the complaint was not in accordance with what the Constitution requires, which is the right of an impeached public official to due process. And the requirement of due process states notice and hearing.
Ergo, what you mean is that if you successfully prove your allegations, the Senate must perforce dismiss the complaint.
I do not think there is nothing illegal in that.
Well, that is precisely the problem. After 7 weeks and 27 days, we are now going to decide it on a practically the arguments that you have stated. But I was in the prosecution in the case of President Estrada. The same issue arose, the defects and all. Our argument is that the House impeaches, the Senate hears and decides. What the House transmits to the Senate, faults and all, everything, defects and all, will have to be accepted by the Senate because the Senate cannot direct the House on how to make an impeachment complaint, because the Constitution simply says that the House impeaches, the Senate tries and decides. So, if I'm thinking about the ultimate end of this goal, you're asking us to, in effect, pass judgment on what the House did. This defense is asking the Senate to decide and say the House is wrong. The House did this and did that. Now, can we do it as a Senate? But the House prepares the complaint. And just like in the Estrada trial, defects and all, it was accepted. That is the President. It was accepted. That was the argument. So, in fact, let me ask for just a little while. No? Prosecution, do you have any objection to the statement of that Congressman will be presented here? This is not my question. This is what Senator Escudero, who already spoke before me, asked me to ask.
We would object, Your Honor, because the House has already performed its constitutional mandate of filing, as brought out by the good Senator. The House has the exclusive power to initiate all cases of impeachment. And the House, through that mode of direct filing under subparagraph 4 of Section 3 of Article 11, indeed filed by the vote of almost 2/3, not only 1/3. And the power of impeachment is an emergency power. Where can you find an act of a legislative body that the vote required is the minority, 1/3? Because you want to make an officer accountable. So that portion...
I think that's been sufficiently explained. So, that's Justice Cuevas, my friend. I mean, that is the only question we have now. You're asking the Senate to nullify, in effect, what the House did. It's just...
I was just, if we did that, Your Honor, we have predicated our action on the decision of the Supreme Court, Your Honor, that we can raise violation of the impeached public official to due process before the House. And if it is not acted with favor, we can bring it even before the Senate. That is the ruling of the
Supreme Court. In the Davide case, the Davide case never reached the Senate.
No, that is not the Davide case, Your Honor. I'm sorry.
I'm sorry. Whatever you are referring to.
It's the Francisco case.
Oh, Francisco case. Now, it reached only, it did not get out of the House. So the ruling was still, the Supreme Court made a ruling over a decision or action made by the House. But in this case, the Senate has already acquired jurisdiction.
Precisely, that was the basis of the ruling in that case, that if it is not honored by the House of Representatives, then you can bring it up before the impeachment court, which is the Senate. That's not my pronouncement.
Which is also my
That is the
question.
pronouncement of the court. And it remains valid, Your Honor, unless modified, reversed, or revoked by the Honorable Supreme
At any
Court.
rate,
May I, Mr. President?
Yeah.
You had Christmas season. You could have brought that to the Supreme Court, just the same as in the Francisco case, before it reached the Supreme Court, or before the Senate, before the Senate acted on it. You know? But the Senate has already acquired jurisdiction. You want
There is no possible time, if Your Honor please, to bring it. It was a blitzkrieg action. If you had gone over our complaint, we delineated very particularly and specifically why we were not able to act one way or the other. It's like being hit by thunder, Your Honor. Wala na.
Thank you very much, sir. Thank you.
At any rate, the chair would like to end this matter and decide it so that we can proceed.
Mr. President,
Yes?
Senator Pimentel and Senator Pangilinan. Senator Pimentel wishes to have the floor. Just
The gentleman
Before you,
from Misamis Oriental.
I will just solicit a fact, Mr. President, which might help you decide the issue, the pending issue. Mr. Counsel, did not Chief Justice Corona file a petition with the Supreme Court? And that petition also questioned or raised the issue of denial of due process?
That's correct, Your Honor.
So you are pursuing that issue before the Supreme Court, and at the same time pursue it before this impeachment court.
That's correct, Your Honor.
Okay.
They are predicated, however, on different factual menu, Your Honor.
Anyway, that's just a factual, a question of fact, so that the presiding officer will be guided. But just to make it of record, although it has been, it is basic doctrine that it is the Supreme Court which interprets the Constitution, in my opinion, the House and the Senate are not prohibited from interpreting the same Constitution, and especially Article 11 on impeachment, because if you read the sections on impeachment, these are actually directed to the House and to the Senate. Hence, in my humble opinion, the Senate can interpret Article 11 on impeachment, and we will rule on the pending issue given or asserting the Senate's power to interpret the Constitution. Just as the Supreme Court can interpret the Constitution, the Senate, as the impeachment court under Article 11, also has the same right to interpret the same sections in the Constitution.
As of date, I do not find any valid objection to such an interpretation that may be made by this Honorable Impeachment Court, Your Honor.
Anyway, thank you for that additional factual input, Mr. Justice.
Thank you also. Thank you also.
The gentleman from Pampanga, are you raising your hand? You have 2 minutes.
Yes, thank you, Mr. President. Just very quickly, Mr. President, all throughout the 27 days of the trial, we have been focused on the articles of impeachment. Article 1, Article 2, Article 7, and Article 3. And then we have abandoned, or the prosecution has abandoned the other articles of impeachment. With these affirmative defenses being raised, may we know under which article will the evidence presented, to be presented or being asked to be presented, under which article would it fall? Because I ask this, Mr. President, because we have on many occasions prevented the prosecution from presenting evidence precisely because it is not within the ambit or does not fall within any of the articles of impeachment. Therefore, it is immaterial, irrelevant.
That is...
So may we know under which article will these affirmative defenses be, will it fall under?
That's directed against me, Mr. Senator.
Yes,
Oh,
yes,
thank you.
Justice. Thank you.
Now, it will cover the entirety of the impeachment complaint, Your Honor.
All right? All right? Now the chair will make a ruling. Under the Constitution, the sole power to try and decide all impeachment cases belong to this court. Only this court has the jurisdiction. The Supreme Court has no jurisdiction to try and decide impeachment cases. That's one. Once the articles of impeachment reaches this House, the command of the Constitution is that trial shall forthwith proceed. Due process is not only the sole function of the House of Representatives. Due process is a function of this House that tries and decides all impeachment cases. The facts in this case are that an impeachment articles of impeachment was referred to this Senate by the House. 188 members of the House filed that articles of impeachment to this House. And the named complainants in that impeachment case are Representatives Nirsi Tupas Jr., Joseph Emilio A. Abaya, Lorenzo R. Tanyada III, Reynaldo V. Umali, and Arlene J. Bagao. When this Senate, sitting as an impeachment court, received the articles of impeachment, it issued the proper processes to notify and inform the respondent of the existence of these articles of impeachment against him, and requested or ordered the respondent to file his answer within 10 days, which the respondent Chief Justice did. And a reply was equally filed by the prosecution with respect to the answer filed by the respondent Chief Justice, so that at least this court has followed the principle of due process that is demanded in a case like this. And so therefore, having made the ruling that this court assumed jurisdiction under the full faith and credit given to the processes of the House of Representatives, and knowing that it has jurisdiction, it proceeded with the trial, and so therefore, as much as we want to accommodate the desire of the defense, this presiding officer, with the permission of the impeachment court, regrets to deny the desire of the defense. So you proceed to present your evidence.
May we know if the defense is ready, Mr. President?
We are ready, Your Honor.
All right, proceed to present your evidence.
May we call on Congressman Tobias, Your Honor. Tobias Chanco, Your Honor.
What is the purpose of this witness?
Well, we ask permission, Your Honor, that Attorney Dennis Manalo be allowed to handle the taking of the testimony of this witness, Your Honor, and he will state for the record the purpose for which Congressman Tobias will be presented as a witness.
Yes.
Thank you, Your Honor.
Counsel for the defense may proceed.
Good
Please
afternoon,
state the purpose of this witness.
good afternoon, Your Honor.
Yes.
We are presenting, Your Honor, Congressman Tobias Chanco to prove or lay the basis or introduce the factual background, Your Honor, of the material defenses in C.J. Corona's answer for all the articles of impeachment. Particularly, Your Honor, we are referring to paragraph 2, paragraph 3, 4, 5, 9, 10, 11, 12, 13, 14, 15, Your Honor, of the prefatory statement, Your Honor, in the answer. With the permission
Of
of
the
the Honor.
articles of impeachment.
Yes, Your Honor, for all the articles of impeachment, Your Honor.
Are you going to present him to establish the fact that there's no verification?
Your Honor, in view of the ruling of the Honorable Court, we have decided, Your Honor, to forego that purpose.
All right.
Because it will not serve any useful purpose in the proceedings anymore.
All right, proceed.
Thank you, Your Honor.
Put him under oath.
Please raise your right hand. Do you swear to tell the truth and nothing but the truth in these impeachment proceedings?
Yes, Your Honor.
So help you God.
Thank you.
Counsel, proceed.
Mr. President, just a parliamentary inquiry. Did we hear the counsel state that this witness is being presented for the articles of impeachment, Article 1?
All the articles of impeachment.
All
Your
the
Honor.
articles of impeachment. Mr. President, we have discussed this in caucus earlier, and the issue of whether or not evidence can be presented on the other articles other than 2, 3, and 7.
We have already made the ruling to that effect. In fact, I read the ruling orally into the record that this court will not allow any reception of evidence on Articles 1, 4, 5, 6, and 8. Neither the prosecution nor the defense will be allowed to present any evidence for or against these 5 articles because it has been withdrawn by the prosecution and this court will not consider them at all. They will not vote on them, they will not accept any evidence on them, and they will not render any verdict on them. And so, be guided accordingly.
Yes, Your Honor. When we referred to all articles of impeachment, it is understood that we are only referring to the remaining articles of impeachment that have not been withdrawn by the prosecution. Your Honor.
Proceed.
Good afternoon, Mr. Witness.
Yes, good afternoon, Your Honor.
Mr. Witness, since when have you been a congressman?
I've been congressman since noontime, June 30, 2010, and this is my first term as congressman of the Lone District of Navotas, Your Honor.
For the record, Mr. Witness, can you just please state your name?
I am Tobias M. Tiangco of 90 M. De Vera Street, Navotas City. Tapos na, nag-oath na ako, boss.
Yeah. And Mr. Witness, for the record, what district do you represent?
The Lone District of Navotas City, Your Honor.
This is the fishing capital of the Philippines, am I correct?
Fish trading capital of the Philippines. It used to be the fishing capital, but it's now the fish trading capital, Your Honor.
And Mr. Witness, what is the estimated population of Navotas?
During the census of 2007, I think it was over 250,000, more or less, Your Honor.
Prior to being a congressman, Mr. Witness, have you occupied any other government position?
Yes, Your Honor.
Ano po yung mga posisyon na ito?
Ako po ay naging acting mayor from June 30, 1998 to February 1, 1999. Ako ay bumalik sa pagka-vice mayor from February 1, 1999 to May 2000. At nung namatay ho yung nakaupong mayor, ako ay nag-assume ng post ng mayor ng May 2000 hanggang 2001. Tapos ako ho ay tumakbo ng mayor ng 2001, 2004, and 2007, Your Honor.
Napakahaba po ng inyong pinagsilbihan sa inyong bayan ng Navotas. Tingin ko'y mahal na mahal ho kayo ng mga Naboteños.
Yes, Your Honor. Diyan na ho ng table ko.
There's no question there. May we ask that be straight from the record?
No, wait a minute. Counsel, proceed. You're on direct examination.
Yes, Your Honor. Mr. Witness, you mentioned that you are a congressman, a first-term congressman. Are you familiar with the duties of a congressman?
Yes, based on the rules of the 15th Congress, I am familiar with our duties and responsibilities, Your Honor.
And what are your duties as a congressman?
Mainly, it's legislative work. It's attending, if you will define legislative work, most of the legislative work is attending committee hearings and, of course, in the afternoon, attending plenary sessions, Your Honor.
Aside from these activities, are there other activities that you participate in as a congressman?
Formally, none, Your Honor, but there are other informal functions and other informal meetings, Your Honor.
What are these informal meetings? What are they called?
Social gatherings, caucuses.
Ano po ba itong caucus? Yung sinasabi niyong caucus, ano po yun?
Doon ho sa House, ang caucus ho is a private meeting of a group of people depending on what type of caucus. No? Depending kung anong caucus ang sinabi. Pag sinabi ho all-member caucus, ibig sabihin ho caucus ng lahat ng membro ng House. Pag sinabi ho all-majority caucus, yan ho ay caucus ng lahat ng membro ng majority. Pag sinabing minority caucus, yan ho ay pagpupulong ng mga miyembro ng minority. Pag sinabing party caucus, yan ho ay caucus ng isang partido. So, depende ho kung anong klaseng caucus po, Your Honor.
Ano po ba ang ibig niyong sabihin sa majority sa Kongreso o mayorya?
Base ho sa aming rules, yung hong mga miyembro na boboto sa nanalong speaker, yun ho ang mga miyembro ng tinatawag na majority. Yun naman hong boboto sa susunod o sa number 2 ay yun ho ang mga miyembro ng minority.
Nabanggit niyo po na yung pong caucus ay isang private meeting. What do you mean by that? That it's a private meeting?
It's a private meeting in the sense na kung kami ho ay nasa committee, meron hong roll call at may agenda. Kung kami ho ay nasa plenary, meron din ho nagsisimula ang plenary, siyempre sa pagkanta ng national anthem, sa pag-invocation, roll call, tapos order of business. So meron hong agenda. Sa caucus, minsan ho, wala hong formal advice at wala hong agenda na sinasabi. Kung minsan ho, sasabihin sa amin, there is an all-member caucus. Sasabihin o makakatanggap po kami ng text na there is an all-majority caucus. Ganun ho. Pero wala hong definite agenda kadalasan ang caucus.
Sinabi niyo po kanina na bilang congressman, kayo po ay umattend din sa mga caucuses. Ano po bang mga caucuses itong na-attendan niyo na?
Ang huli ko hong na-attendan caucus ay yung all-majority caucus noong December 12, 2011 ho. Kami ho ay nakatanggap ng text message noong siguro 6:30 to 7 p.m. ng December 11 galing ho kay Attorney April. Siya ho ang sekretarya ni Speaker Belmonte Ang natanggap ko hong text message is there will be an all-majority caucus at 2:30 p.m. tomorrow at the Andaya Hall. Pero wala akong agenda.
Wala akong agenda.
Opo.
Ito pong pagkatanggap niyo po nung text message na ito, no, na meron kayong all-majority caucus. Meron po bang nabanggit kung ano po ang tatalakayin dito?
Already answered, Your Honor.
Wala po.
Already answered, Your Honor.
Yes, Your Honor.
Ano po ang naging, what was your reaction, Mr. Witness, to upon receipt of this notice?
Wait, Your Honor, because he's making me laugh, Your Honor. ang una kong reaction noong natanggap ko po yung notice na magkakaroon ho ng all-majority caucus ay medyo kinabahan ho ako dahil noong araw na yun, may mga ugong-ugong sa text din na magkakaroon ho ng impeachment kay Chief Justice Corona. So, ayoko hong, I was hoping against hope na sana hindi yun ang pag-uusapan doon sa all-majority caucus. Sabi ko ho, sana RH bill na. Ngunit parang hindi pa pwedeng RH bill kasi kung RH bill yun, dapat all-member caucus. So parang sabi ko, mukhang ang pag-uusapan dito ay yung impeachment ni Chief Justice Corona.
Ano po bang mga preparasyon ang ginawa ninyo bago dumalo sa caucus na ito?
Ang preparasyon na ginawa ko is I tried to psych myself up, no? Pinilit kong pilitin yung sarili ko na kung sakaling impeachment ang pag-uusapan, pikit mata na ho akong boboto ng yes sa impeachment.
Bakit po?
Tatlong bagay ho. Unang-una, masama ang naging experience ko noong hindi ho ako bumoto ng yes sa impeachment ni Merceditas Gutierrez dahil yan ang number one. No? Number two, alam ko may numero na eh. So bakit ka pa hindi boboto? At number three, ayoko hong mapag-initan I don't want to catch the ire of the most powerful man in the country who has a very high popularity rating, and that is the President of the Philippines. No? Alam niyo, 9.5 years, kalaban ko si GMA from 2001 and 2010, and the President can make life miserable for you. With the vast powers given under the Constitution, pwede hong maging miserable ang buhay ng isang tao pag kinalaban, pag hindi kagusto ng Pangulo. So for those three reasons, sabi ko, ayoko na ng gulo, I will just psych myself up to vote. No?
You mentioned na nagkaroon po kayo ng masamang experience sa impeachment ni dating Ombudsman Merceditas Gutierrez. Ano po itong masamang experience na sinasabi ninyo?
Ang impeachment ni Merceditas Gutierrez, kung matatandaan ko ho, is March 21, 2000. Your Honor, can I get my notes just to make sure of the date?
Your Honor, the witness is asking permission to refer to his notes so that he could get the date exactly.
The witness is authorized to refer to any material that he has.
Your Honor, the witness, Your Honor, is going over his notes.
Yes.
Let the record show that.
Yes, Your Honor.
Proceed.
Your Honor, March 21 ho, pinagbotohan ho yung impeachment ni Merceditas Gutierrez. Noong Sabado ho, before March 21, so ang ibig sabihin ho nun is March 19, may mga kumalat na text messages allegedly coming from June Abaya, Chairman June Abaya, na sinasabi yung mga boboto ng no sa impeachment ni Merceditas Gutierrez ay 0 as in 0 sa PDAF, no?
Your Honor, we have to object to that because the witness is testifying on a text message.
No, Your Honor, but let me proceed.
The witness may answer.